In this video, I'm going to give you a quick overview of bankruptcy law, specifically personal bankruptcy law. I'm going to cover topics such as what is bankruptcy, what are the pros and cons of filing bankruptcy, and what happens to you when you file bankruptcy. If you're somebody who is contemplating filing bankruptcy, you should watch this video. I'm Beckett Cantley, author, professor of tax law, and senior partner at the law firm of Cantley Dietrich. Okay, let's get started. Question 1. How devastating is filing for bankruptcy? Bankruptcy protection, if you are going through a very tough financial period and you can't pay your bills, is peace of mind. It is a rough process. It requires a lot of disclosure, and you're subject to a court looking through everything you do financially. But in the end, you get to clean up, a mess that you are obviously, because you're in bankruptcy court, can't handle otherwise, and you get a fresh start. So bankruptcy for a 6-month or so period, unless you have some very unusual issues, is stressful, but it's no more stressful and can oftentimes be provide much more peace of mind than going through trying to bail out a very difficult financial situation. So when is filing for personal bankruptcy the best option? Personal bankruptcy is reserved solely for when you are completely overwhelmed with your financial situation. In most people's cases, they have a single unexpected event, like a healthcare situation where you have very large medical bills you just will never be able to pay, or you otherwise have a lawsuit or something else that the judgment is so large it's just impossible for you to get out from under. Otherwise, you would need to have slowly put yourself into so much debt that you just can't make all the payments, and you're not going to be able to make those payments in the future. Under those conditions, you should seek bankruptcy protection if you just can't work out those debts with your lenders. The issue is that you can only file bankruptcy, Chapter 7 personal bankruptcy, which is what we're mainly talking about here, once every 8 years. So you do not want to file bankruptcy unless you absolutely have to do it. What happens if someone files for bankruptcy? Well, the main thing is when you're preparing for bankruptcy, you're going to need to provide your attorney, unless you're doing it on your own, which I would not recommend. You need to provide your attorney with everything in the world that you have financially, all statements for every bank accounts going back for several months, if not years, depending on if you've made any transfers or anything that the court might want to look at. And you're going to have to answer a bunch of tough questions. But in the end, your attorney should be able to put all that together in a package that's filed with the court. And you will be in a waiting period until the court wants to talk to you. And then you have a creditors meeting. A creditors meeting occurs, or you will walk into a room. There'll be a series of people sitting at a table, bankruptcy judge, people representing potentially creditors, and they will ask you a series of questions based on your filings. And what they're trying to uncover is whether you have any assets that they can take into your bankruptcy estate and distribute to your creditors. So they may order a particular thing that you disclose to be paid over. They may just ask some questions about why you did X, Y, or Z, but it's pretty quick usually, unless you have some unusual issues. And you walk out of that room, and within some period of time, you will either hear that they have additional questions through your attorney, or they will just grant you a discharge. Very rarely does this turn into anything that involves a repeat performance, other than maybe if they want to ask you some specific follow-up questions that they've generally provided in advance to your attorney. So how can you avoid personal bankruptcy? Well, we're presuming here that you are so underwater and your creditors are not willing to work with you well enough that you must seek protection from the courts. But leading up to that decision, you should approach your creditors and let them know you're contemplating bankruptcy. And often they will work with you on a payment schedule or close up your credit line and fix the amount that you owe and potentially cease interest or reduce interest or some other incentive that may allow you to pay back what you owe at that time. You were required as part of the bankruptcy procedure to seek credit counseling, and often credit counselors can assist you in approaching your creditors this way. If, however, there are just too many creditors or the payment options they provide you are not satisfactory to your income and your other needs, then you're going to strongly want to consider a Chapter 7 bankruptcy. What are the pros and cons of declaring personal bankruptcy? The pro is that you will get an automatic stay upon filing the bankruptcy from the collection of the debts that are already accumulated against you. So you will cease having creditor calls or any other collection efforts while the bankruptcy procedure is ongoing. Also, at the end of the procedure, once you receive a discharge, assuming you do, you will have a clean slate where you will not owe any of the debts that you had at the time of declaration, other than a couple of exclusions, which are super creditors. Super creditors include the IRS for taxes. If you owe income taxes or other taxes, you are going to end up having to pay those over time or work something out with the IRS after the time that you receive your discharge. Until you are discharged, though, while the automatic stay is on, the IRS cannot collect against you. Another super creditor would be if you owe alimony or spousal support. You must continue those. You're not going to get a discharge for those. Those obligations continue, and they continue at what your agreed rate is. So the pros are with the exception of a handful of super creditors, you are going to be able to get a discharge of your debts and get to start over. Cons. The cons are you've used your card that you only get to use once every 8 years. And if you get in trouble again, you're not going to be able to just file another Chapter 7 bankruptcy and get out of it. Not until the 8 years have passed. The other con is that your credit will be destroyed. You will have very little chance of acquiring much in the way of a loan, a credit card, other than perhaps a secured card or some very small credit card that is only really of use to people for buying small items. The lending establishment considers bankruptcy for many years to be a real big red flag, even though you would think that if you file bankruptcy and you owe nobody anything, but you still have money coming in, that you would somehow be worthy of credit again because you can't file bankruptcy for 8 years. That is not the case. That's not how they think, and that's not how they'll respond. So you should just plan that you're going to be living off your debit cards and paying cash and writing checks for things for the foreseeable future. Is it better to declare bankruptcy or do debt consolidation? If you can do debt consolidation, it is much preferable to bankruptcy. Bankruptcy is your last resort. You only want to file that if a debt consolidation or other workout program with your creditors is just not going to work. You simply do not have enough money to pay into it. If you have any way of structuring your debts where you can make the payments without filing bankruptcy, you should, because those debts will, once gone, you cannot do it again for 8 years. Also, you end up in a sort of creditor purgatory where for some number of years, and there's no fixed number for credit for any particular creditor, but it is a number of years, you're going to have a very difficult time getting any kind of loan or credit card. Can you use bankruptcy to get rid of student loans? Federally backed student loans currently cannot be discharged in a Chapter 7 bankruptcy. There are proposals on the Hill that may allow for some bankruptcy protection for student loans, but as of right now, there is no such protection and you'll be stuck paying them. Do you need a lawyer to file for bankruptcy? I cannot, you can file without having a lawyer, but I cannot imagine someone actually doing that. The the changes to the 2005 Bankruptcy Act created a great level of detail and a number of requirements that without the assistance of an attorney would be difficult to meet for the average person. The also engaging with the courts and potential creditors, it's really, really good to have somebody who is your representative dealing with them in your stead. Otherwise you do not get the peace of mind that comes with a automatic stay in bankruptcy. How can you improve your credit score after bankruptcy? Well, following bankruptcy, obviously, most creditors will not provide you credit. However, if only one spouse in a marriage has to file bankruptcy, the other one does not, and the non-filer can put you on their credit cards as an authorized user, and they will report to your credit report, and each monthly payment will increase your credit score. Otherwise, you can get a secured credit card generally, and that means you make a deposit of cash into a bank and they issue a card that's basically a virtual debit card, but it acts like a credit card. They maintain the amount on file and they report it as a credit card. And the payments, every time you make a monthly payment, your credit score will go up. It is very difficult to get a mortgage or a car loan or anything else that would help establish credit until a number of years after you filed. So you just need to plan that your credit score is going to lurk down there near the bottom for quite some time and slowly creep its way back up. What is it like to declare bankruptcy? You get an automatic stay the minute that you have filed bankruptcy. So most people get a real peace of mind, because prior to that, they've had collection efforts made, phone calls, whatnot, from their creditors, and they, right after you file for bankruptcy and your attorney notifies the creditors of such, they will cease all that collection. You then enter a kind of a waiting period where you wait to go and have your creditors meeting, as we discussed before, and in that time frame, you keep making money and you keep paying your regular bills. Every penny you make that's legitimately made after you file bankruptcy is yours to spend. We're only speaking about Chapter 7 now. That's a little different, Chapter 13. But in a Chapter 7, every penny afterwards, as long as it was legitimately made after the filing of the bankruptcy, and not somehow kept at bay and then paid to you after you filed, you get to spend on your regular bills, food, gas, all the rest of it. So you do get a general peace of mind. And then once you get a discharge, you generally, unless there's some exception that we discussed previously, you do not owe any more money to the creditors that were chasing you. What are the principal differences between Chapter 7, Chapter 11, and Chapter 13 bankruptcies? Chapter 11, to start with, is generally for business owners who have an ongoing profitable business that they want to preserve. And so the bankruptcy protection is a way of restructuring their debts to continue the business, generally to protect employees and the value of the business for that should provide a method for getting the creditors made whole. Chapter 7 is a complete liquidation bankruptcy for individuals, and that's where you basically surrender all your non-exempt assets into bankruptcy court, and you get a discharge, except for super creditors, which can include the Internal Revenue Service and spouse that you owe alimony or child support to, that wipe out all of your personal debts at that time, and you do not have to pay anything further back. However, you can only file Chapter 7 once every 8 years. So if you play that card, just know you cannot get into financial trouble again and wipe it all out for 8 years. Chapter 13 is a way for individuals to file a bankruptcy where you're going to structure full repayment of your debts to your creditors, much like an 11. You pay over what you're making into court, and the court distributes it based on an agreed plan for a number of years, generally 4 years. And it can be converted into a 7 if those payments just aren't working out and you're not restricted by having filed Chapter 7 within that 8-year period. So most individuals elect for Chapter 7 if they have to file bankruptcy. But if you filed bankruptcy within the last 8 years, or you really just want to restructure the debts because they're, over a period of time, because you can pay them without liquidating, but you are going to have to need the court's protection to do so, then you would file a 13. Otherwise, 7 is preferable. That's it. We finished our short tour through the personal bankruptcy code. If you like this video, please make sure to subscribe to my YouTube channel right now. Just click on the subscribe button below this video. Also, whether you're a CPA, financial advisor, or high net worth individual, please go to BeckettCantley.com or CantleyDietrich.com and check out our blogs for tips for preserving wealth.